Hi there, everyone. My name is Kiki Dilly, and I am one of the partners here with Altitude Community Law, and I handle collections for our HOA clients, me along with two of my attorneys in this department as well. We are going to get started here in just about 1 minute, just making sure that any other stragglers or anyone that is having trouble getting in has an opportunity to get in here. In the meantime, on your screen, you'll see the PowerPoint presentation in the center of your screen. This should take up most of your screen. And then there's also a small box on the bottom right-hand side of the screen with the video feed, which is me. Hi. On the left side of the menu, you can select questions and answers icon and type all your questions in there, and we'll answer those at the end of the presentation. CMCA credits are automatically generated once the webinar hosting site provides an attendance confirmation report to us, and will be sent out via email within 48 hours following the webinar. These credits are not transferable, so they're just for whoever is actually in the webinar. If you have any questions, please email Sean at education@altitude.law, or you can call Sean directly at 303-991-2076 if you have any questions about receiving your CMCA certificates. But like I said, those will take a few days after the webinar so we can confirm who is actually here. So we are going to go ahead and get started. We have a lot of information to cover today, so I'm not going to be able to go super in-depth about everything, but it'll be a good overview. Keep in mind that if you have a management company or board that you think would benefit from going more in-depth on any of these subjects, or maybe hearing the same presentation for everyone, or we can even stretch it out and do 2 hours, or we could do it over multiple days. I've done an hour one day and then an hour a week later to cover everything again, so that you have some time to digest things and ask questions that are specific to your associations or for your management companies. I'm happy to come out to your management company, probably virtually now, but to do this presentation again if you think that that would be beneficial. So please contact me if you think that that would be helpful. So we'll start out, and the first thing that I always like to address is make sure that you as a manager understand what successful collections is for your particular board. I know it's really easy to try to have the answer that you think is right for everyone, but it is important to try to keep in mind that you probably have a lot of different board members or a lot of different boards that have different philosophical, economic makeups, things like that, that collections might look differently to each one of them. And we want to be sure that we understand what those successful collections looks like, because some boards are very aggressive and they want to keep going after people, and they think that we should try to collect every dime. It doesn't matter how much money it costs. Let's keep going after these people that have maybe lost their home in foreclosure, maybe moved out of state. Just because of the principle of the matter, they want to keep going. Other boards are more conservative and they don't want to keep throwing, as they say, good money after bad, and are more likely to want to write off a balance to bad debt if it looks like collections isn't going to be quick and simple. So it is important to bear in mind that the makeup of every board is different and the character of every board is different. So we want to bear in mind, we want to do what is successful for them, and it's not necessarily a one size fits all kind of answer. So I also like to touch right at the beginning on the collection policy. Most of you I'm sure are aware at this point, but back in 2014, new laws went into effect, and that law was based on House Bill 1276, which is why it's sometimes referred to as the HB 1276 collection policy. And those laws made every association, or nearly every association, responsible for having very specific language in their collection policy before you can send someone to either collections with a collection agency or collections with an attorney. This language has to be in the policy before you send someone to collections. So you can't send them and then on the back end try to fix the collection policy. This has to be in place beforehand. And so sometimes you'll see emails coming from my office that you tried to turn someone over to our office for collections, but we're not able to move forward. until we get a compliant collection policy in place. And that is because of this law from 2014. So it's always good when you're onboarding a new association to check those documents and make sure that collection policy is updated before you actually need to use it and send someone to collections. Otherwise, it's really easy to have unnecessary delays in the process that we could have dealt with beforehand. So among other things, the collection policy has to state when assessments are due and when they become delinquent. So they're due on the 1st of every month and they are considered delinquent, for example, if the check isn't received by the 10th of every month. The collection policy has to say the amount of the late fees, interest, and return check fees. And bear in mind that Colorado law caps return check fees at $20. So we see a lot of collection policies that say $25 or $50, but the Colorado law does cap that at $20. Circumstances and terms of when a payment plan will be allowed, and that is also laid out in the law. That's not something that we can change to be more restrictive than what is laid out in the law. And we do have to offer most people a payment plan of at least 6 months. The policy also has to say that at least one of your delinquency notices is going to contain all of the following information all within one notice. We can't have some of this information in one notice and some information in another notice. It has to all be within one notice. You have to say the total amount due and the accounting of that. You can either divide it out and say, here's all the unpaid assessments, here's all the unpaid late fees, or what is easier, if in your letter you just say, we have attached a copy of your ledger that itemizes the balance due, and then obviously make sure that that ledger is actually attached to the letter that goes out in the mail. That's generally the easiest way to satisfy that requirement. Your letter needs to say whether or not a payment plan is allowed. We see a lot of letters that say you may be allowed to enter into a payment plan, but unfortunately that's not compliant under the law. You have to say you are permitted to enter into a payment plan, or if they fall under the very restrictive categories of not having to be offered a payment plan, your letter can say you are not allowed to have a payment plan, but you can't be wishy-washy about it, and you can't say you may or may not be eligible. We generally recommend, for ease on the management company side, to just offer a payment plan to everyone so that you're not constantly going in to try to figure out, has this person have they had a plan before? Have they defaulted before? Are they eligible? Are they not? It's much easier from a document production standpoint to just offer that payment plan to everyone. Worst case scenario is that it delays your process for a few months while they make a couple of payments and then fall delinquent on their payment plan. So you have to tell them they have 30 days to cure the balance. That includes getting back to you and agreeing to a payment plan. They don't have to have had the entire balance paid in that 30 days. They can agree to a payment plan in that 30 days, but we do have to give them 30 days to get back to you. You can't change it to 10 or 14. That's something that we've seen a lot of lately, that deadline being changed. You have to give them the name and the contact information of the person the owner can contact to get additional information. Unfortunately, a lot of letters we see say something like, please contact your property manager, or please contact our AR department at this email address. The law actually requires a human's name to be listed there. So make sure that you have that in your letter. You also have to say the legal remedies that are available if they don't pay the balance. And there's language that's very specific in the statute that is usually just copied and pasted directly into the letter. And it says something like, if you fail to respond to this letter within 30 days, the association has the right to file a lawsuit against you, to attempt to collect against you, to file a lien, foreclose on the lien, things like that. Your collection policy also has to address foreclosure, and it has to say that in order for the board to be able to foreclose, one of the laws that went into effect at the beginning of 2014 is that in order to proceed with a foreclosure, the balance has to be equal or greater than the equivalent of 6 months of assessments. Most of the time, that's not going to be an issue because a lot of times it takes nearly that long to get through the association's collection policy delinquency letter process. And so the balance, by the time it comes to us, is well over 6 months. It's not necessarily 6 months past due, but when you count in all of the late fees and interest, the balance is at least the equivalent of 6 months of assessments. And so that's usually not a problem. The bigger issue that comes up is that in order to proceed with a foreclosure, the board has to vote on that particular property and vote to proceed with foreclosure on that particular property. They can't give the management company or our office any sort of blanket direction that anyone who gets a balance over $5,000 or $10,000 or is a year behind or whatever the case may be is going to be sent to foreclosure. The legislature wanted to know that boards, first of all, understand the gravity of the situation, that they are voting to foreclose on someone, but they also want to make sure that the boards are aware of the particular properties that are being foreclosed on. So we do have to have some sort of confirmation that there was a board vote, whether that be in the minutes or a foreclosure resolution that documents that either of those can satisfy that requirement. So a few pre-collection techniques to touch on before we get into what the collection process looks like. We always recommend that you provide people as many options to pay as possible. If someone shows up at your office with a check, great, take it. If someone shows up with cash, take it, give them a receipt for it. If you have the ability to allow people to pay on your website or maybe set up for ACH payments, all of that makes it more likely that someone will actually pay the bill because it's easy to pay. You have to send out your notices as they are laid out in your association's collection policy. And I know from a management company side, it's really easy to put everyone in the same process and say, we send out, a 10-day courtesy letter, then we send another letter at 30 days, we send out another letter at 60 days offering the required payment plan, and then we send people to collections or whatever your process is. Make sure that you are actually tailoring your process to what that association's collection policy says, because that is what's going to matter. If this homeowner fights it and goes to trial, they're going to say, well, my collection policy requires 3 or 4 letters at these time increments, and I only got 2 letters. And it's not a good defense to come in and say, well, the management company's process is that we always send out 2 letters, and so we didn't do those other letters. Unfortunately, that is something that happens because it's easy, and I understand falling into that trap, but the judges do want to see that the actual association's policy has been followed. So make sure on the management company side that is happening. Something that seems silly but can actually make a difference is if you send out coupons, make sure you're also providing a pre-printed return envelope or a little label to put on the return envelope, because sometimes people's handwriting is terrible and checks go to the wrong places. So if we can alleviate that with a return envelope, great. It's always important to educate your owners. If it's something that can go in an email blast or an association's newsletter, it's always great to educate homeowners on both sides of the collections process. First, we want them to understand why they're paying assessments and what their money is going to. So if you can say, hey, here's where all of your money went last year. As an association, we repaved the parking lots, or we put new roofs on all of the the condo buildings, or whatever the case may be, or we did something to the clubhouse, and look at all these great things we're doing. But it's also equally important to help people understand what might happen in the event that they don't pay. You can always tell them, we have the right to foreclose. We can pull your right to use the community pool, which, given COVID, that may or may not be a threat right now. But in normal times, we do have people who contact us and say, I need access to the pool for the summer. My kids are going crazy. How much do I need to pay you to get access to the pool? So that's always a good thing to remind people that if your documents allow, if they don't pay their assessments on time, they won't be able to access the pool. That can be really effective. And finally, we like to talk about this more at the beginning of the year, but it's still applicable now. If your association's documents allow for acceleration of assessments, at least you can get the full year's assessments paid before you have to deal with someone falling back into collections maybe at the beginning of next year. So if you have additional questions about acceleration, please let me know. But that is a good, useful tool sometimes. So if none of those work and you've gone through your delinquency notice process and you have to get the attorney involved, on our end, if they come to our office, those go to a generic email address that actually come to me, and then I distribute them out among the teams in our department, and I put the email address on there in case anyone wants it. We always find that the faster you can send people to us, the lower the balance is at that point, and it's easier to collect from people. Our first step that we have to take whenever a new turnover comes to our office is that since I am a debt collector, I'm required to send out my own 30-day demand letter. That's in addition to that 30-day payment plan letter that you guys have to send. This is a different kind of animal. This is something that debt collectors have to do, and it basically tells the homeowner, your association has hired us to collect this balance. Here's how much we're showing due. Here's who you owe, your association. And here's 30 days that you can contact me, get a payment plan, pay it, or dispute the debt if you want. Now, we find that the faster you can send things to us, the easier it is to recover. And the reason for that is that most of the people that we deal with in collections, we are not the only creditors coming after them. Every once in a while, you have someone who isn't paying the association out of principle because they don't think the snow removal is good enough, or they don't like the board, or whatever the case may be. But most of the time, people just don't have enough money to go around to everyone that they pay money to. And so the sooner we can get these people in our collections process, the more likely we are to collect. If they are able to pay voluntarily, it's much easier for someone to get a letter saying you owe $800 versus a letter that says you owe $8,000. It's just easier for them to wrap their head around how they can get out of that particular debt hole. So we always say, send it to us sooner, we'll get you better results generally. Plus, if we hit it faster, we're not going to be competing with hopefully as many other creditors for a finite amount of money. So after that demand letter expires, we have this clear and simple process that we go through. I'm actually only going to cover the very first line of this process, but I wanted to include this in there so that you all have an idea of what the process looks like. So we send out our demand letter. If we can get someone paid, if we can get them on a payment plan, great. If not, we figure at this point they've received at least a few letters from the management company or from the board if it's a self-managed association, and they've ignored those. They have gotten a letter from me, and they've ignored that as well. So at this point, they're probably not going to pay voluntarily, so it's probably time to escalate things and get the courts involved. So we draft a lawsuit that's called a summons and complaint. We send these documents out for service on the owner, and that's really our first stumbling block in this process because those documents have to be handed to the homeowner or someone over 18 at their house. People are really good at avoiding process servers if they're so inclined. We can't leave the documents in the mailbox. We can't post them on the door. We can't give them to the neighbor. We have some options outside of that, but really the process server has to serve either that person or their relative at the homeowner's home. So any information that you or your boards can give us is really great. The example that I always use that is a real example actually happened. We had someone that we couldn't get served because he wouldn't open the door to the process servers. And the board said, I don't understand why you can't get this guy served. He comes home every night at like 6 o'clock. He gets his 2 giant poodles and he takes them and walks them around the neighborhood. Why can't your process server come and serve him then? I'm like, well, he can. We didn't know that he did that, which is why we didn't know to send the process server out then. But now that we know, we will absolutely tell the process server. Process server showed up, sat there and waited for him for a few minutes. Guy came home, got his poodles, came outside, and the process server said, here you go, here's your lawsuit, you've been served. So any information that you can give us that we can pass along to the process servers is really helpful. We do have the option to try to serve people through the sheriff if we're not able to get them served from a process server. That can sometimes work a little better because people are more likely to open the door to a police officer than, a random guy standing on there, especially during COVID. So we can do that, but the problem is the sheriff can be a little bit more expensive, and also they don't try as hard. They will only go out once or twice, maybe 3 times during a service period to try to serve someone, whereas the process servers tend to go out a lot of times to try to get somebody, because a lot of them don't get paid if they don't serve someone, or they get paid a lot less. They get, $10 or $15 if they're not able to serve, as opposed to the, 40 or 50 they get if they can. So they're happy to get the information. Once someone is served, we have that court date already set for them, and I or one of my other attorneys will, during normal times, show up in court, or now we do it all virtually. And we're happy to talk with people, get some sort of resolution for them, a payment plan for them if they show up for court. If not, which is what happens most of the time, the court will say, well, they have defaulted because they failed to show up in court when they were supposed to, and so the association wins by what's called a default judgment. And that's really the goal of the lawsuit process, is to get a judgment entered against the owner, because that is when our process and our collection options switch from being voluntary payments to being involuntary payments. The other option homeowners have is that they can file an answer with the court and tell the court why they think they shouldn't have to pay the balance. In those cases, most of the time the court is going to order us to go to mediation to try to work it out beforehand. Or sometimes if we're not able to work it out at mediation, we'll go ahead and have to proceed with trial. So regardless of how we get judgment, whether it's because the homeowner defaulted or we went through trial and judgment got entered there, that is the goal of this process, is to get judgment. And once we have judgment, we can start doing involuntary collections. Generally, the one that we're looking at first is what's called a writ of continuing garnishment, or more commonly referred to as a wage garnishment. In that case, we ask the court for the wage garnishment, they authorize it, we send it for service on their employer, which is great that we don't have to serve the owner because the employer is not trying to avoid service. And then it's the employer's problem to start withholding a portion of the homeowner's paycheck every time they get paid up until that judgment has been paid. That's a really great way to get payment if we're not able to get it voluntarily from the homeowner. The other option that we look at a lot is called a bank garnishment, which sort of works the same as a wage garnishment, and that we request the court to authorize a bank garnishment. The court issues it, we then serve it on the bank, and on the day that the bank is served with that garnishment, they hold any money in the homeowner's account up to the amount of the garnishment. And then the problem is we then have to serve the homeowner with bank garnishment information. Now, at this point, the homeowner has been served at least once by a process server, and now we're trying to serve him again. A lot of times it's the actual same person who shows up on his doorstep, and so he's not very inclined to answer the door at that point. So that can be a bit of a stumbling block with the bank garnishment. In addition to that, we don't have any way of knowing if someone has $5 in their bank account or $50,000 in their bank account. Probably don't have $50,000 because they're in collections, but things happen. Sometimes people have their name on someone else's bank account, like an elderly parent, so that they can help them pay their bills or something like that. We can get access to that money too. So sometimes we do get access to a lot more money than we're anticipating. Sometimes the bank comes back and says, great job, you held $3.12. So the bank garnishment, it has a longer process, but also it is less predictable than the wage garnishment, which is why we generally use the wage garnishment option first. So in addition to everything that I just said, back in June of last year, in response to COVID, the Colorado State Legislature made some new laws that impact what they referred to as extraordinary collection actions. That impacts us on the garnishment side. Before we're able to garnish anyone right now, we have to send them out a letter that tells them, hey, we're about to garnish you. If you don't want to be garnished, if you have been financially impacted by COVID, please contact us and tell us that you've been financially impacted by COVID, and then we're not allowed to garnish you, at least until June 1st. This has been extended a couple of times. It was initially supposed to expire in November of last year, and then I think it got extended to maybe April, but at any rate, it's now currently set to expire June 1st. It may or may not be extended again. We don't know. We're certainly watching. But until this expires, basically we're under these requirements. If someone contacts us in response to that letter and says, I've been financially impacted by COVID, don't garnish me, we're not allowed to ask for any kind of proof. We're not allowed to garnish him. So we have to take their word for it. The good news is that most of the time, the people who respond to these letters are then willing to agree to a voluntary payment plan, because at least we've started a conversation with them and we've reached them and we have been able to address the debt. Every once in a while, we have someone who says, don't garnish me, I'm not able to make payments. And unfortunately on those, we're a little bit stuck until this garnishment law expires. But luckily, those are kind of few and far between right now. Most of the time when these letters go out, people ignore those, just like they've ignored all the letters from you guys and the letters from us leading up to this. The other thing about this garnishment law is on the bank garnishment side, it exempts the first $4,000 in a bank account from garnishment. So most of the time, the people that we're dealing with don't have $4,000 in their bank account. I don't have $4,000 sitting in my bank account either, so I can understand that. So essentially, bank garnishments are not a great option for us right now, and we are not doing many of those until this expires. So the good news is that what this law didn't impact is the vast majority of what we do. It didn't impact anything on the management company side as far as your delinquency notice process. It didn't impact our ability to send out letters, to sue people, to hold them responsible for their debt. Basically, we're still going to trial. We're still getting judgments against people. We're still doing wage garnishments against people. We're still requiring people to answer asset questions, and we can foreclose on people. We can do receiverships on their properties. All of that stuff fell outside the definition of an extraordinary collection action. So that's really good news for associations, and hopefully those requirements will be expiring soon anyway. So as a typical problem that I like to throw in here, what do you do if an owner is served with a lawsuit and shows up at a board meeting or calls your office and wants to discuss settlement with you or the board or wants a payment plan? The answer, anytime someone has been sent into collections, always refer them back to whoever is handling the collections. That's a great benefit to you guys, that you don't have to engage with these people and get in the middle of it anymore. Same goes for your board. They have that option and that recommendation to just say, look, I'm sorry, it's not that I don't sympathize with you, but I need you to talk to the attorneys. The reason for that is not because we're trying to rack up fees or anything like that. We actually don't charge anything to talk to homeowners, so they're not incurring any additional fees to contact us. But the reason is we bill out our fees monthly. But over the course of the month, we're working on files, we're incurring fees, we're drafting letters, we're filing documents with the court. And so the board and the management company probably don't have the most up-to-date attorney fees amounts that are due on a particular property. So anytime a homeowner calls you or emails you, we want to have them be referred back to our office, only because we have the most up-to-date balance due to provide to them. So outside of those options, there are a few other options that are out there for boards. A receivership is one that can be a great option in some circumstances. It's basically us asking the court to authorize a third party to come in and act as a landlord on the property. The receivership is only an option when the property is either vacant or tenant occupied. We can't kick an owner out of their property in order to put a receivership in place. So the ways that we know that a property is vacant, tenant occupied, there's returned mail coming back from the property, if the process server goes out to the property and says, I think this property is vacant because, there's packages at the front door from 3 weeks ago, or mail stacked up, or the weeds are, this high, they can tell a lot of the time. Or if the board knows that the property is vacant or rented. In those cases, we file a motion with the court. Some judges will allow us to do this before we have judgment against the homeowner. Others require judgment first. It's very judge specific. And we can also ask the court to authorize a receivership, even if we aren't able to serve the homeowner Again, that's very judge specific, but it's within their discretion to allow that if they want. So that can be a really great option on cases where the property is vacant and we just can't locate that owner. So once the court authorized the receivership, the receiver, who is a third party, but we tend to work with the same receivers over and over because we trust in their ability to do this in a professional and effective way. The receiver goes to the property. If it's tenant occupied, he introduces himself to the tenant, he produces his court papers and explains to them the situation. And that tenant will start paying their rent payments to the receiver instead of to the owner. If the property is vacant, they'll get access to the property. They'll bring a locksmith out there, get the locks changed, get inside, make sure that the property is in rentable condition. Sometimes that's just a cleaning. Sometimes it's more in depth, like we have to get the water turned back on, the power turned on, things like that. If there's trash in the unit, they have to get that cleaned out, but they don't have to make it a great place to live. Like, they're not going to be putting in granite countertops or anything like that. They just have to make sure that the refrigerator is functional and things like that to make it a livable space. They'll then find a tenant, put a tenant in the property. They do list the property for rent at slightly below market value because a couple of situations. First, they want to get someone in there very quickly, but also they're putting a tenant into a usually a fairly short-term lease. It's not uncommon for receiverships to be 6 to 9 to 12 months, something like that. And so because it's a shorter term lease, they usually have the rent discounted just a little bit because we're asking someone to live there for a short time. And there is some instability that comes along with that. So he'll locate the tenant, put the tenant in the property. The tenant then pays the receiver until the balance is paid. The receiver provides regular updates to not only the association and the management company in my office, but also to the court so that the judge can keep track of things and see what's going on, see where the money is going, things like that. The receiver is paid hourly for his activities on the property. Usually, if there's nothing really weird going on with the property, the first few months of rent payments will go to the receiver to pay him for what he did, getting the property ready for rent and locating the tenant, things like that. And then after the first few months, the vast majority of the rent payments will start coming to the association, and the receivership goes into what the receiver calls a status quo status, which just means they're billing about $100, $150 a month just to keep in touch with the tenant, make sure everything's going okay, process those rent payments, and send them on to the association. And everything over and above that amount is going to the association every month. So once that receivership is in status quo status, the association starts seeing pretty substantial payments towards their balance due. All right, some factors to consider if you're thinking about a receivership. If the first mortgage has a foreclosure pending against the property, depending on how long out that sale date is set for, it may not be a great option for a receivership because we do want to have enough time for the receiver to start making money for the association before ownership of that property transfers through the foreclosure sale. And then at that point, the receivership has to stop. So once a foreclosure is pending against the property, there's kind of a ticking time bomb out there that we're trying to rush ahead of. So if there's already a first mortgage pending, a first mortgage foreclosure pending, it may not be a great idea to jump into a receivership. What's the average rent for the community versus the balance due? If there is $500 due and the average rent is $1,500 a month, probably doesn't make sense to pay a receiver a whole lot just to get a very comparatively small amount of money. Likewise, if average rents are $1,500 and the balance due is $40,000, it's going to take forever to try to get paid through a receivership. So also probably not a great option. Bear in mind that most landlords are smaller landlords and they rely on rental payments to help them pay the mortgage on that property. So if we are taking those rental payments away from them, we have basically started the clock on a foreclosure being started eventually. If we aren't able to get in, get paid, get out quickly enough, it's possible that if we have a receivership going on for a year or two, a foreclosure is going to pop up eventually. So we're really trying to hit that sweet spot between there's enough due to justify the cost of a receivership, but not so much due that it's going to take a long time to get paid, and we might possibly push that property into foreclosure and still not get all the way paid. So something else to consider is the condition of the property. A lot of times, especially for single family homes and townhomes, you can get an idea of what the inside of the property looks like just by looking at the outside of the property. It's much harder with condo units, but sometimes the board will have an idea. The receiver can certainly give us an idea if he can go out and talk to somebody or just look at the property. Every once in a while, receiverships go bad. But in the event that that happens, if we get access to the property and say there was a hoarder that lived there, that happened to me several years ago, the receiver got into the property and there was just floor to ceiling boxes everywhere. The board said, I don't want any part of this. And we just kind of backed out of the door and said, never mind, court, we don't want to proceed with the receivership. And that's fine. You always have the option to do that. But that is pretty rare. Another option that is available to boards is a judicial foreclosure, which I'm only going to touch on for just a second, but is an option that's available. That is not a public trustee foreclosure, which is when the mortgage company is foreclosing. A deed in lieu of foreclosure is something different as well. That is often done whenever a mortgage company is about to foreclose and they agree, rather than going through the whole foreclosure process, the homeowner agrees to just walk away from the property and they will sign the property back over to the mortgage company. Something else that was happening a lot more several years ago when the housing market was kind of flipped the other direction was short sales, which is when there is not enough equity in the property to pay everyone who has a lien on the property. And so the mortgage company and sometimes other lien holders will agree to take smaller balances due. They'll settle their balances in order to allow a sale to go through to at least start over with a new homeowner. So judicial foreclosure is when the association is foreclosing against the property and it goes through the court system, which is why it's called a judicial foreclosure. And we're basically asking the court to allow the association to foreclose on the property to satisfy the balance that was due to the association. You want to foreclose generally if you have people who are chronically delinquent, if they've been in collections 2, 3, 5, 7 times, and they're just not getting the message that they need to keep their assessments up to date. Sometimes a foreclosure can be an effective message. If you have what we call judgment-proof people, which are people where maybe they don't work, they're retired, or they're students, so they don't have wage income that we can garnish, or if their only income is from Social Security or disability payments, things like that, that we aren't able to garnish because of laws against it, then sometimes those people are referred to as judgment-proof, and a foreclosure is going to be a more effective collection option against them. If there's a large account balance that's due, say there's more than $10,000 or $15,000, $20,000 due, a foreclosure can be your most effective way of collecting rather than trying to collect such a high balance through garnishments or a receivership. Also, if the owner is a company like a bank or an LLC, a trust, an estate of a deceased homeowner, a lot of times that property, well, not in the bank situation, but the others, a lot of times the property is the biggest asset that those companies own. And so we might as well just go after the property rather than trying to locate a bank account for an LLC. We have owners who can't be located or can't be served. Foreclosure can be an option against those because we have more service options in those cases than we do in the collections cases. So that can be a great option. And we always want to make sure that there is a substantial amount of equity in the property so that we can make sure that it is going to be an attractive option to the owner to pay off the balance that's due to the association and not lose their equity in that property. Foreclosure is a lengthy process. Uncontested can take 9 months or more. Contested can take a year or even a lot longer because these cases take place in district court, and district courts handle more complex cases, and it can be a lot more difficult to get on their docket to have a trial or hearings or whatever needs to be done. Some common outcomes from a foreclosure action. Best case scenario is the homeowner pays the balance and the foreclosure is stopped. That's great. Sometimes if they don't do that, if there's enough equity in the property, we'll have investors purchase the foreclosure at the sale. They'll pay the balance due to the association, and then the investor will take ownership of the property. I mean, as far as the association is concerned, that's just as good of an outcome because they get paid, they get an investor owner who presumably is either going to rent the property and take care of it, or they're going to maybe fix it up and flip it and sell it themselves. Either way, the association got paid. Sometimes, as I said before, the first mortgage can start their own foreclosure on the property, and mortgage companies are able to go through a different foreclosure process than the association has to go through, and it's a much faster process. So depending on where we are in the foreclosure process, it may make sense to stop the association's foreclosure and just let the mortgage company foreclose rather than throwing more money at the association's foreclosure, only to have it preempted by the mortgage company. But in the event that that happens, our foreclosure department communicates with the board and gives them all the information and a recommendation of how to move forward. Every once in a while, not at all likely right now, but every once in a while, the association ends up becoming the owner of the property because the homeowner doesn't pay to stop the foreclosure and no investors show up at the sale. In the event that that happens, the association has the option to sell the property. You would still have to pay off the mortgage because the mortgage does have a lien against the property. But then any profit or any money above and beyond what is owed to the mortgage company goes to the association. So that's not a terrible outcome if that happens. You always have the option to put a renter in the property and just collect rent payments until the mortgage company comes in and eventually forecloses. Or we have had a few very rare cases where the association actually wants to keep the property, and so they refinance it and take responsibility for the mortgage, and they retain that property. It's only happened twice that I'm aware of, so it's pretty odd, but it's an option. In those cases, there was one where the association wanted to have an on-site maintenance person live at the association, live on-site. And so that was part of their goal, was to purchase a property through a foreclosure and keep it for the on-site maintenance person. So sometimes for the right circumstances, that can be the ideal outcome, but it is pretty rare right now. All right, we're gonna touch on bankruptcies really fast. Chapter 7 is a bankruptcy that homeowners frequently file when they are unemployed or severely underemployed, and they just don't have enough money to pay all of their creditors. It's a fairly quick process, usually takes about 4 to 9 months. And once that bankruptcy is discharged, the personal obligation of that owner is no longer their responsibility. So we wouldn't be able to sue the owner for any balance that was due as of the date they filed their bankruptcy. We can't garnish them. We can't do anything like that. During the bankruptcy, we can't try to collect the debt. You guys don't want to send out any delinquency notices to the owner. We have some bankruptcy attorneys that have gotten really aggressive about making sure that no one is violating the automatic stay. So make sure as soon as you receive a bankruptcy notice, you let the attorneys know so that we can get involved and protect the association as much as we can through bankruptcy. And B, make sure that they are removed from that automatic process on your end so that they don't get delinquency notices while they're in bankruptcy. Once they're discharged, they are no longer personally responsible for the balance that was due as of the date they filed bankruptcy. Now, usually, unless there's some other filings in the bankruptcy will not impact the lien against the property. So the lien against the property remains valid for the full balance due, even the pre-bankruptcy balance. So if that person refinances their property later or sells to a new owner, make sure on your status letter balance, you're including any pre-bankruptcy balance and any post-bankruptcy balance, because that lien is still good for the whole balance, even though there was a bankruptcy. If the owner decides to give up their property in the bankruptcy, and I include this one statutory reference in here because it's something that comes up a lot, owners seem to think that if they tell the bankruptcy court they're giving up their property in the bankruptcy, that they don't have to pay any future assessments, but that's not accurate in a Chapter 7. In a Chapter 7, they are still responsible for any assessments that come due starting from the date that they filed their bankruptcy, moving forward, as long as they continue to own that unit. So if it takes the bank a year or two to actually foreclose, they are still on the hook for those assessments that came due from the date they filed to the date that their ownership of their property actually transfers. The other type of bankruptcy that we're seeing a lot of right now is a Chapter 13, which is when you have homeowners who are employed, they have income coming in, so they want to repay the majority of their creditors, or at least some of their creditors. They just need a break from the collections. They need a break from garnishments, things like that, so that they can repay the majority of their creditors. These take a long time. They usually last about 3 to 5 years. Just like in a Chapter 7, creditors can't do anything to try to collect the debt. So all sort of collection efforts have to stop, whether it's garnishments, delinquency notices, all that stuff. Now, in addition, that is different from a Chapter 7, anyone else who owns that property with the person filing bankruptcy is also covered by that automatic stay. So if we have a husband and wife and only the husband files a Chapter 13, we can't do anything to try to collect from the wife either, because that co-debtor stay covers both parties. Most of the time, the association will be repaid what was due to them through the bankruptcy, but it does take a long time. It takes about 3 to 5 years to fully get paid, and it depends on whether or not the debtor is actually, the homeowner is actually keeping their property. If they're keeping their property, the association should be repaid through the bankruptcy. Now, the caveat to that is that we have to make sure that the bankruptcy plan covers the association. And the deadlines for filing documents in the bankruptcy are quick, and they happen right at the beginning of the bankruptcy. So if the association misses those deadlines and a plan is confirmed in the bankruptcy that doesn't provide for the association is probably going to be out of luck in collecting the balance that was due in the bankruptcy. So the take-home message, which I think I say here later, is that if you get any notices of bankruptcies, especially Chapter 13s, make sure you get that information to the attorney right away so that we can jump on the documents that need to be filed in the bankruptcy and make sure that the association is covered and will get paid. Just like in a Chapter 7, the lien will remain against the property for the full balance due. In the event that the owner keeps the property, like I said, the balance that was due as of the date the bankruptcy was filed has to be included in the bankruptcy plan because you're a secured creditor. The homeowner also has to continue paying regular assessments during their bankruptcy. And if they're not doing that, and everything was filed in the bankruptcy like we should have done right at the beginning, we can ask the bankruptcy to be dismissed. And that's a huge threat because bankruptcies are really expensive for homeowners. It's not uncommon to see attorney fees of $5,000, $7,000, $9,000 that they've paid. So they don't want to lose out on that money and have their bankruptcy dismissed because they failed to make a couple monthly payments. So that's a huge threat that we have to get people to continue paying. Now, in the event that they give up their property in the Chapter 13 bankruptcy, they still have to tell the bankruptcy court about the debt that was due to the association, but unfortunately that then makes the association an unsecured creditor, and they're only going to get paid pennies on the dollar. They're going to get paid with all the other unsecured creditors like credit cards and things like that. So that's a bit of a bummer. But unfortunately, there's not a lot we can do about that. Most of the time, though, one of the reasons that people want to file a Chapter 13 is because they want to keep their house. So we always try, it's more likely than not that someone will keep their house and you will get paid through the bankruptcy. So the takeaway message is that if somebody files bankruptcy or you receive any bankruptcy documents, you want to make sure your association's attorney is notified right away so that we can get in there and make sure that the association is covered in the bankruptcy, but also confirm that you stop sending delinquency notices because those bankruptcy attorneys are super aggressive about violations. All right, right at the end here, I want to look into my crystal ball a little bit and see what we know about the future or what we're predicting about the future. Like I said before, currently those garnishment restrictions expire on June 1st, but they can always get extended. The Colorado legislature is in session right now. So as far as I am aware, they haven't put anything out there to extend that yet, but that very well could be a last minute thing and it could get extended again. The other grumblings that we've heard in the industry is that it's possible that that $4,000 bank garnishment exemption. I hope it doesn't, but in the event it does, we'll deal with that when it comes. So the other thing that is interesting, I think, to think about is right now there is a moratorium against mortgage companies foreclosing on mortgages that have government-backed loans. That will eventually expire. The experts right now are predicting that that will lead to a flood of new foreclosures coming onto the market, which makes sense, right? The people who have not been able to pay their mortgage because of COVID have been relying on these foreclosure moratoriums to keep them in their homes. When those run out, a lot of those mortgage companies are going to call a lot of money due, and those people, probably a lot of them, don't have large amounts of money to stop foreclosure at this point. So there's probably going to be a lot of foreclosures. That will probably, in Colorado, lead to a lot of more houses being put up on the market for sale because people recognize that our housing market is great right now. They get enough money out of a sale of their property to pay off their mortgage company, get out of their house. That's a good thing for associations that are owed money because, as you know, when that property goes to sale, you guys get a status letter request, and because of your lien against the property, the association gets paid at the sale. That's great. Something else that will come of more foreclosures hitting the market is that sometimes if there are properties with a significant amount of equity in them, if the owner isn't able to stop the foreclosure before it goes to sale, sometimes investors will show up to the sale and purchase the property. And if there are multiple investors that want an attractive property, sometimes they'll bid against each other, which ends up in the property being purchased at foreclosure for an amount that is higher than what was due to the mortgage company. That's called an overbid, when there's more funds out there than what is due to the mortgage company. The good news for associations is that as a lien holder, we have the option and the opportunity to tell the public trustee who handles these foreclosures that we want that overbid money because the association has a lien that is otherwise going to get extinguished in the foreclosure sale. We have access to this overbid funds and we have to act quickly. We only have 8 business days to notify them. But when we watch these foreclosure sales, we're always watching for overbid funds. And when we see them, we'll file the documents with the court and get the association paid that way. That's a great outcome to this flood of foreclosures. The other thing that is probably likely to happen is that you guys are going to start seeing a lot more homeowner turnover. We might see a lot more banks owning properties. We might see a lot more sales happening because of these foreclosures. So I sat through an interesting talk about a month ago, maybe now, that was put on through the CAI Rocky Mountain chapter that was Kate Watkins, who is the chief economist for Colorado, which is evidently a nonpartisan position with the state. And she was talking about predictions for the near future, a year or two out for Colorado and the housing market and the economy and things like that. And she was saying they are predicting that because of this forthcoming flood of foreclosures into the market, they're expecting a short-term decrease in property values when all of these homes flood the market for sale. But that because we have so many more people, because of COVID, able to work remotely now, and Colorado remains a very attractive place to live, that they are expecting the flood of people from outside the state coming to Colorado to continue. And so we'll have a lot of people still coming into Colorado, which will help counteract that dip in property values that they're expecting, and that they're expecting a pretty quick recovery in our housing market than in other parts of the country because of that. So while we, according to at least the state, their expectations are that we may see a quick drop in property values when we have all these foreclosures that start, but that we will rebound pretty quickly. So bear that in mind, I guess, whenever you're planning for staffing levels for status letter requests or new homeowner packets that need to be sent out and whatnot, that and for your future budgeting purposes as well, that for your associations, that we may see a quick impact with property values decreasing, but hopefully long-term, we won't be in a similar place to where we were back in 2008, 2009 when I first started doing this work, and there just wasn't any collections options out there. So that's really good news to hear for our associations and for our clients, that even though we may see some short-term financial impact because of these foreclosures, hopefully looking long-term, your associations may be okay from a financial standpoint. We just might see different people living in the properties than are there right now. So that's kind of the looking to the future information that I can give you right now. That's all I have for today. I have listed here our website that has a lot of information. Also my email address. I know I went through a ton of information really quickly, so please feel free to reach out to me to ask any questions that you might have. Or again, I'm happy to come and talk at management companies, talk to your boards about what's happening with their delinquencies and their collections, and what options are available and what are not. In the meantime, I have a couple of questions here. So we have one question that says, if the association files a foreclosure first, then the bank files a foreclosure, who has priority? Since the association foreclosed, does the bank need to settle the HOA outstanding balance? No, is the short answer. Because the mortgage companies go through a faster priority, a lot of times they hit their finish line first, and the law says that the majority of the mortgage company's lien is a higher priority than the association. So whenever the mortgage company forecloses, they wipe out the association's lien by statute, and it doesn't matter who started their foreclosure first. Now, the consolation prize to the association is what's called a super lien, and that is the equivalent of 6 months of assessments. That is a higher priority than the mortgage company's lien. So the result of that is that if the mortgage company forecloses, the association is going to get paid 6 months of assessments because of that foreclosure, but they're not going to get paid the full balance due. Now, that doesn't do anything to the balance that's due from the owner. If we know where the owner is, we can still go after the remaining balance from them, but that money is going to come from the homeowner. It's not going to come from the mortgage company that's foreclosed. Next question is, if we go through a foreclosure process and the owner finally pays the outstanding balance, can we also accelerate payment to the end of the fiscal year and have that condition part of the foreclosure? Yes, provided your documents allow for that. Some documents provide some sort of notice or waiting period to the association before you can accelerate, but as long as there isn't some sort of limitation there, then we can accelerate at any point. Like I said, that is more useful at the beginning of the year, assuming your fiscal year is a calendar year, but that is something that could be done now to require anyone, excuse me, to require someone pay off the remaining balance due. That's absolutely fine. On the management company side, usually how that's done is there's just a line item added to the ledger that says it's accelerated assessments June through December, with the big number of that 7 months of assessments on there. So speak to whoever is handling the foreclosure to make sure that that is an option for that particular association. But generally, yes, that is something that can be done. And then the last question I have here is, can we file a lien on a property if the owner paid the assessment late but refuses to pay the late fees and penalties? Oops. In other words, he now only owes fees and penalties. Yes, technically there's a balance due and you can file a lien. You may not want to take that much further. In the event that you actually try to collect that, you might get some pushback, and it might be not worth the attorney fees to try to collect that balance, depending on how much it is. That's kind of a cost-benefit analysis for the board to make. Usually we recommend, depending on the amounts, it's probably a good idea to just waive those and let those go. But if it's a substantial enough balance and it's something that the board is doing consistently and not just with one homeowner, then yes, from a legal standpoint, you could file a lien for just those fees and penalties, but whether or not you actually want to pursue them is kind of a different matter. So that's all the questions we have, and that's all the time we have. Like I said, I know I throw a lot of information at you, so if you have any other questions, please feel free to contact me directly. I'd be happy to answer any other questions. Otherwise, thanks for joining me, and I hope you all have a great rest of your day. Bye-bye.